All right, good evening, everybody. I'm Jeremy Wechsler, Wechsler Estate Solutions. Tonight, you're joining me. Thank you so much for being here for our estate planning webinar. Tonight, if you have any questions, please use our chat option. So that's going to be at the bottom of your screen. To find that chat option, if you're on your computer, you can hover your mouse over the Zoom screen and you should see a bar at the bottom. Same thing with mobile. If you're on a mobile phone, tap the screen and a bar should appear at the bottom with the chat option. You can type your question in for that in that chat, and we will answer as many questions as we can at the end of the webinar. So please type your questions in at any time, and again, we will get to them at the end of the webinar. If you're having trouble hearing, make sure that your device volume is turned up. At the end, I'm going to have a link to schedule some time with me if you'd like, and then also some supplemental materials. So we will send that link to you in the chat at the conclusion of the webinar. And if you don't get it or you miss it or have to leave early, we will also send you an email with that. If you did not register for the webinar for whatever reason and you have a link to come on, please let us know that through the chat so we can add you to that list if you would like. So let's get into it. I am an attorney and a financial advisor. I have licenses for both. I've been practicing law in estate planning since 2009. I'm certified in estate planning and tax through Temple University, on top of having the law degree. While I was an attorney for some years, I worked at one of the largest Bucks County firms as a senior attorney. I love estate planning. I love financial planning. I love retirement planning. And I'm really excited to talk to you about all of that tonight. So that we don't go all night, I put an agenda together. And first, we're going to talk about some essentials when it comes to estate planning. I will get into some of the documents in more detail, powers of attorney, wills, trust, and then the difference between them and what you might need and some considerations on those. We're going to do a couple of cases, some strategy sessions there, where that will really sort of light up some of these issues and hopefully resonate to some degree with all of you. And then we'll talk about sort of the next steps. So looking forward to jumping in here with you guys. We're going to talk about some planning essentials. And the question is, what's estate planning? Is it just documents or is it something more? Obviously, part of it is documents. You've got to have something in writing. But really, when we think about estate planning, there's a lot more thought that goes into it, or at least should go into it. And that's what I want to convey to you tonight. First of all, when we think about estate planning, we think about who gets what and when, and more importantly, avoiding unwanted outcomes. So we want to make sure that we have a plan so that what we want to happen does happen. You want to protect your estate while you're living and after you're gone. So unnecessary taxes, fees, creditors, long-term care. You want to make sure that all of that is safeguarded to the maximum extent possible. You got to plan more than once in your life. So your plan isn't static. And I think about like a baseball team, right? You may get a new player and you have to change the lineup. After a couple of years, the lineup's going to look completely different and you have to change your game plan. And when it comes to estate planning, it's really the same thing. Your life and your circumstances are going to change over time. Finally, and related to that, a good estate plan, again, it's done a few times over your life. Okay, so when you have children, when you go through incapacity, when you retire, thinking about long-term care, and then of course, upon death and preserving your legacy, these are all different pieces of the estate planning, and you want to come back to at least a few times during your life. So when I think about estate planning, it's really, you're going to get into nitty gritty, but you want to think big picture as well. And you want to make sure that all the pieces fit together. We'll talk about that. But planning matters really more than ever right now because we live in such an uncertain time. That provides some hidden benefits, by the way, but it creates some more complexities. We have family members that are in more complex and unique situations and maybe not as doing well as you did. Maybe they don't have the same values as you have, but you still want to leave them your estate. You still want to leave a legacy. How do you plan that? So there's lots of questions around that. And then tax laws always changing. Every administration that comes in, there's always tax laws that are going to change. Right now, Congress is working through tax laws. Who knows? They may change how we deal with estate taxes or other taxes related to estates. So all of that is really key, and it matters so much that today, if you haven't planned, that you start planning. And you can't plan in vacuum. So if you're looking at doing your will, it's not enough just to do the will. You want to look at that in relation to your retirement plan, to your investments, to your tax planning, to long-term care planning, and more. And what I always say with estate planning is you want to hope for the best but plan for the worst. So you really want to make sure that you're thinking about all kinds of situations that occur with your family. You know your family, you know your situation, and you know what could go wrong. And so we want to try to plot that out and make sure we cover our bases. Remember, everybody has a plan. So either you've made your plan or the government's made one for you. And we certainly don't want to go with the government plan. That much I can tell you, because there you have no say in who gets your stuff, who directs where it goes. There's no trust that could be created. So it's very limited, and it's probably wrong. It's probably wrong for you. And it certainly will not help to minimize costs, will not help with your legacy, etc. So you want to have a plan. But the other bad thing is having a plan that's so outdated. So if I did a plan back in 1995, that's 30 years old now. And chances are the plan that I made in 1995 will not reflect 2025 or beyond. So you want to go back to it. I'd look at like every 10 years or so as a good marker of time, maybe more, maybe less. It depends on your situation. But if you're not going back to it at the minimum of at least every 10 years, then you really ought to rethink that. So why create your own plan? Well, I just told you, I mean, you don't want to have the government plan, but certainly when you create your plan, there's benefits. There's tax planning you can do. There's protecting vulnerable, irresponsible spendthrift beneficiaries, or even responsible beneficiaries that you're concerned about. Like, let's say you're concerned that one of them may get a divorce, or may have a high-risk profession and have creditor problems in the future, or may go bankrupt. Like, there's all kinds of things out there that you can protect against when you leave your stuff to them. You can end family disputes before they begin. I'll talk to you about in the strategy session some ideas on that. But family disputes, they're pretty common. It's not to say that with every family dispute there's some sort of court case with your estate, but we don't want to take that chance, do we? So we'll talk about that some more. And then really the most important thing, it's overlooked, but that second bullet point, like directing who manages your affairs and your estate, like who's going to have the say as the executor or an agent, as a power of attorney, as a trustee. These are roles that shouldn't be overlooked. And really a lot of thought should go into it. It shouldn't just be, well, it's, my kid because it's my kid, and that's the end of the story. No. You don't want to just sort of put a name down and not really give it a lot of thought. So we'll talk about why that is and how you can, some strategies around that. So estate planning is one piece of the puzzle. When you think about your life and when you get towards retirement, if you're pre-retirement or in retirement, it's your estate, it's your income plan, it's your investment planning, it's your tax planning, healthcare and long-term care planning. All of these really fit together. You can't just do one in the vacuum. You can't just do your will, put it aside, and not think about your other assets. So, and your other parts of your affairs, your life. So these really do fit together, and you really think about holistic planning. And that's what we do at Wechsler Estate Solutions and Franklin Retirement Solutions, which is our sister organization here. So Estate Essentials, I'm going to tick through these really quickly on this slide, and I'll go into some more detail. But the Estate Essentials, the documents that we're looking at, are a last will and testament, a healthcare directive, and a durable power of attorney or financial power of attorney. There's also trusts, which is the last bullet point, And one important piece is any beneficiary designation forms that you might have filled out for any account, these supersede wills. So they're really important that you pay attention to them just as carefully as you do your will and other documents. Really, again, all the pieces fitting together. So I will go back to beneficiary designations throughout this presentation, but you see the only item in there I put on red was that these supersede wills. So it's a really important point. And make sure that your beneficiary forms, designations for IRAs, annuities, life insurance, if you have them on bank accounts or investment accounts, that they're updated. So let's talk about powers of attorney first. This slide is deceptively simple because we really want to hit the fact that you need 2 of these. And when I have clients come in or potential clients come in and say, no, I already have a will, I'm fine, Jeremy, I don't need anything else, I'm good to go, I did my will, and that's all I need. I say, no, the will, we'll have to look at that, of course. It may be good, it may not be good for your current circumstance, but you also need powers of attorney. What are powers of attorney? These are documents that will take care of you, make sure you're taken care of during your incapacity. So if I can't pay my bills anymore, if I can't speak, if I have dementia, whatever it may be, physical, mental, combined incapacity, or just aging, and I don't want to take care of my affairs anymore, the power of attorney allows for you to appoint somebody that you trust in these roles to make decisions for you. With the financial power of attorney, again, you'll see it called different things. It's all the same thing. It's a general or durable power of attorney. It's going to work as long as you keep it active. You can revoke it at any time, but the power of attorney will stay in force until you revoke it or upon your death. A healthcare directive, similar deal. It's sort of a general healthcare power of attorney. It's going to stay in force as long as you're living, and it's usually paired with or should be paired with a living will or an end-of-life declaration. Sometimes it's called an advance directive. That's technically like its own separate piece, but usually the healthcare directive, which covers like general capacity, I get hit by the bus walking out of here, I'm in the hospital for a week, I can't speak, I'm not anywhere near death, but I'm in critical condition, right? I can't speak for myself. That power of attorney, that person can speak for me. Now, if I'm in a coma and I'm not coming out, the doctors determine that, then I have a living will, an end-of-life declaration to speak for me on my wishes. And I've indicated already what I would want or not want if I'm in that very end stage condition. So you want to have both. They're usually paired together, and for good reason, because you want that agent, that person that you trust, that you appoint to be able to take care of all of your healthcare needs. Think of these people as like advocates for you. So you want to make sure that you've got advocates that will look out for your best interests. So I've already hit this. Why are power of attorney so important? I've said they're important because incapacity is a huge issue. And if we don't have them, then what happens? That's really the key to know here. And hopefully it gets you in gear to get them done. Some people say to me, well, I don't want to do the power of attorney because I don't really trust anybody to handle my affairs. Well, unfortunately, there's going to be a time, perhaps, there's a good chance that at some point in our lives, all of us will be incapacitated, me, you, and everybody in this webinar tonight. And so we want to have a plan ahead of time to make sure we get to appoint the person that we want. It may not be the perfect person, but it's better than letting this go through court, which is guardianship or conservatorship. And we don't want to be in court or have somebody in court for us trying to seek guardianship for us, because they're spending a lot of our money. It's expensive. It's burdensome. You have, excuse me, let me go back there. You have a judge that decides who the guardian's going to be. There could be a contested guardianship. It could be a couple people that are saying, I want to be guardian. No, I want to be guardian. I had a client, unfortunately, years ago where they had a guardianship out of state, and she was trying to seek guardianship over another relative, and so was a sibling of hers. And they spent 6 figures each in fighting over this guardianship. This is not what we want. This is not the legacy we want. You can create the power of attorney so that you're in control of your affairs. That is really the best and the only way to handle it. Now, again, you want to choose somebody you trust because that goes without saying, but this person will be your advocate, and you want to feel comfortable. Like, it may not be a lights out sort of situation where you're totally incapacitated, but it may be a situation where, you're 75% kind of not doing well, and you want somebody that you trust to be able to pick up those affairs. And if you don't trust that person, you're not going to give up control. You're not going to allow that person to help you. So you really need to think through who your agent's going to be in these situations. I help clients a lot with that in terms of really getting them to think outside of the box. Sometimes it doesn't have to be your kids all the time or immediate family. So that's power of attorneys. Let's talk about wills and trusts. So a will is not enough. That's the question, but a will is not enough. The other question is, can I do it myself? Yeah, you can do it yourself, but would I recommend it? I wouldn't. There are plenty of software programs out there and websites that will offer you the ability to do your own documents, to do your will, to do your powers of attorney, etc. If you go that route, you go that route, but I think you're missing a part of the bigger picture there, and you're missing out on the advice that you get when talking with an attorney, with the financial advisor, with the retirement planner, because they're looking at things sort of from a broader picture. They're going to ask you questions that you may not have asked yourself, and you're going to have a lot of questions, by the way. I have prospective clients that walk in maybe thinking they don't have a lot of questions, but as we get talking, they have more and more questions because they see that although they wish their affairs were simpler, that's the third point here, each of them has some complexity or wrinkle that's going to require some extra care. So although you can do it yourself, you're pretty much doing yourself a disservice, I think. And I've seen do-it-yourself documents over the years in my time of practice, and I've seen them done wrong. I saw one where the individual came in and he brought me his trust, and I said, are you married? Yeah, I'm married. Well, I said, you cut your wife out. Your wife is not in this document anywhere. Oh, I didn't know that. I thought she was in there. Well, sometimes it's very simple things in there that you're missing. So you save a few bucks, but what are you getting from that? Are you causing more problems later? Probably yes. So make sure that you do it smartly. You shouldn't spend an arm and a leg to do it, but you want to make sure you have a good team in place because you're going to need help. Maybe your affairs are simple today, but maybe they'll get more complex in the future. Maybe your kids, maybe your family's going to have questions, and they want somebody that already knows about your affairs, knows your situation, knows your estate, knows your documents, that can help them when the time comes. So just think about having that team in place and not trying to save a couple bucks, because again, you're probably doing yourself a disservice. And I'll just stop here for a second. I want to talk about a story where clients came in years ago. This is maybe 10 years ago. Husband and wife walks in. We want to do estate planning. Great. We have our first meeting. It goes well, but I don't hear from them again. I don't hear from them till about a year later when the wife has passed. And they come back. The husband comes back at that point, but he's got his kids with him, and his kids don't really get along. There's a lot of disputes. There's some complexities in their estate, and he's kind of pulled both directions. And I always thought about this case because I know that if the husband and wife were able to do the plans together, even though she was gone, they could still speak with like a unified voice, right, against what the kids were trying to pull him in different directions on. So again, although things weren't like completely haywire estate-wise when the wife unexpectedly passed, certainly afterwards it got really hairy for him. And I just want to say again, like, the time to do this stuff is while you're still healthy, while things are good, while you really don't in your mind have to think about this. That's really the time to get to it, because when you wait till things happen, obviously death is too late, but when you wait till you're incapacitated or getting too old to really do much, not great. You really want to be able to think freely and carefully and on your own about this stuff, because as we get older and we have less capacity, less competence, other people are going to try to speak for us. And you don't want that when you're planning your estate. All right. So this gets back to just having that team again. So a lot of folks talk and ask me about trust. They want to pick my brain on trusts, and trusts are a topic that is so amorphous sometimes because there's lots of different trusts. But two types of three types of trust we'll kind of discuss tonight. One is a living trust, which is a will substitute, and that avoids probate, which we'll talk about whether or not that's necessary. Then you have trust for heirs, like what happens when you go and you pass property on. You may need to have a trust so that somebody doesn't get all their inheritance at once. And then special needs trust for any beneficiaries that can't work, that are on public benefits. So there's three types of trust that we'll talk about tonight. We'll hit actually fourth, an irrevocable trust briefly for Medicaid purposes. But when I talk about here, when does a trust make sense? I'm talking about a living trust, which is the will substitute. The next slide is going to show you a comparison between the wills and living trusts. But I would say this trust, living trust, makes sense. Sometimes, by the way, we call it a revocable trust. So you might hear revocable living trust or just revocable trust. It all means the same thing, but it can avoid probate for what's put into the trust while you're living. Pennsylvania and New Jersey, probate is pretty simple, so you really don't have to worry about avoiding probate in the state, and a trust isn't going to get you any better result, generally speaking. But if you have property in multiple states, particularly Florida, California, other states where probate's more difficult, where a court runs everything, you may want to set up a trust for certain assets. We get into protecting special needs beneficiaries, heirs, minors, irresponsible beneficiaries, spendthrifts. If you have a very wealthy estate, if I would say ballpark it at 10 million plus, then we're starting to get into federal state tax territory. The exemption right now is very high before you get hit with federal state tax, $14 million per person. So you have to have a lot of money, a lot of assets to be affected by the federal state tax. That's a moving target. That could change a year from now. That could change 5-10 years from now. So again, working with a team that keeps an eye on the stuff will allow you to be best served, because who knows? Right now, that exemption is very high. Will it go down? Could very well go down. And that means it could affect more people. Trust makes sense when there's very specific privacy concerns. Generally, most people don't need to worry about privacy in this realm, but certainly if you're more of a well-known figure or whatnot, you may have certain privacy concerns. And finally, if you're in a second or third or whatever many marriage, and you've got kids from the first marriage and there's more complexities, start to get into trust planning more to protect both kind of sides, the current spouse, but the kids from the first marriage. So some complexities there that actually I'll address in the session ahead, the strategy session ahead. Hopefully you can all see this clearly. This is a pretty dense slide, but talking about wills versus trust, living trust here. And I've done a side-by-side comparison here to kind of give you a better sense of what is true and what's not true. I'm going to tell you, and this is on the next slide, that most people don't need a living trust, but some do. Again, probate avoidance, that's our first category here. A will doesn't avoid probate. A living trust does avoid probate, but only for assets that you put into the trust. I found a lot of folks miss putting assets into the trust, so they have probate anyway, which is really not cool. Creditor protection. So this is like any debts that you have that upon your death, somebody want to collect against your estate on. In a will, there's no creditor protection. In a living trust in Pennsylvania, there's no creditor protection. So you don't get anything more by putting your assets in a living trust for creditor purposes in Pennsylvania. What about while you're living? So that the next one, the third one, is creditor protection for you. And that should say while you're living. You don't get any creditor protection with a will while you're living. Definitely not. And with the living trust, you don't either. Irrevocable trust, maybe, but first of all, you start transferring stuff when you know there's somebody coming after you. That's potentially fraud. And you lose control of your assets when you put them in an irrevocable trust generally. So all in all, you don't really get protection in Pennsylvania. There's other states that may allow for better protection. Most people don't need to worry about that, but there is, it's not offshoring, but there's other states that have more favorable asset protection laws, but you pay an arm and a leg to do planning there, and you still don't know if it's really going to work. Pennsylvania inheritance tax, we've got one. We're one of 6 states that still has some sort of inheritance tax. A will or a living trust or a beneficiary designation, none of them avoid the tax. Please don't let somebody sell you on a living trust because they've told you that it'll avoid inheritance tax. It does not. Federal state tax, both a will and a trust can help you minimize the tax, but there's more flexibility in a living trust. So if you have a high net worth estate, you're really probably going to be in a living trust territory. When you get to distributions and control of inheritances, generally a will is going to leave you're going to leave assets outright. Like all of your stuff will go directly to the person. At the end of the day, they'll get a check. There's no trust involved. You can have what's called a testamentary trust under the will. But in a living trust, you can do the same thing with more flexibility, and it can hold more complex assets. So it depends on your estate. If you've got more complex assets and more stuff going on, you might want to use a living trust to make sure that all of that passes under trust for the heir. So it's something, again, we'll talk about more one-on-one. Wills are simpler generally. Trust, you get into more complex territory, and that goes with the fees. Generally, and I can't speak for every attorney or really any attorney, but with wills, you might be under $1,000, but with the living trust, you're several $1,000s in at least to start with. So that's a little bit on wills versus trust. So the bottom line on trust is that for a straightforward estate where you don't have property out of state and you don't have those privacy concerns, you don't have federal estate tax issues, a living trust is probably going to be unnecessary. There may be a few cases here and there where it makes sense, but generally unnecessary because, again, the things that people come to me and say, hey, I need a trust because it means I won't pay taxes or I'll avoid probate. Again, having a trust, there's a little mistake in the slide. Having a trust could avoid probate. It depends on how the trust is funded during your life, but it may not avoid probate completely. It's not going to avoid Pennsylvania inheritance tax, and it's not going to avoid creditors from collecting against your estate, whether that's in a trust or not in Pennsylvania. So again, once you get past like a straightforward situation, the trust starts to make more sense for certain clients, and it may be more helpful in certain situations. But how do we know when a trust makes sense? That's really sitting down with an attorney one-on-one to determine. So we could talk generally tonight, give you some sense. I'm going to go into a couple cases in a second here, but whether you need a trust, it's really going to be individualized. So what I hear a lot is, well, my neighbor had a trust, my cousin had a trust, so they told me I need the same thing. So here I am, I need to get that trust. And lo and behold, we look at their affairs, we go through a series of questions and whatnot, and we find, listen, you really don't need a trust. Okay, your situation doesn't warrant it. We don't want to do over planning, we don't want to do under planning. So you have to find that balance. You have to strike the balance when it comes to this planning. And I've seen a lot of over planning and a lot of under planning. The person with hardly any estate that has a huge binder with 100 pages of a trust document, and then people with $100 million estates that have a 2-page will. Okay, they don't align clearly, because when you have a $100 million estate, you're in federal estate tax territory and beyond, and there's a lot of careful planning that you would do that you wouldn't do if you have $100,000. Okay, so again, a lot of the stuff I say when we're sitting down and planning is common sense, but a lot of people put stuff on the internet, and a lot of people try to send you stuff and sell you stuff on things that you don't really need. So it's tough sometimes to sift through some of the stuff. So I'm hoping to cut through some of that with you here tonight. So let's go into some case studies. Let's talk about, I have 2 for you here tonight. First one is Betty and Stan. And I'm going to give you first the facts. Again, it's a little dense, so do the best we can in a short period of time. Then I'm going to give you the next slide with some suggestions on what we might do with their case. All right, so Betty and Stan, they're in their mid-60s. They're married, and they've got 3 adult children. Their estate is close to $2 million, about $1.8 million. Stan's IRA is currently worth $350,000. It was at a high of $425,000 before the market declined. Stan named Betty as the primary beneficiary of that account, and then one of his 3 children. Remember, he has 3 children. One of the 3 is a contingent beneficiary because he said the others are spendthrifts. So he didn't feel comfortable leaving money to them directly. He wanted the one kid to inherit the money from that account and then dole it out to the other 2 kids. The children, though, generally don't get along. Betty and Stan own a second home in Florida, but Stan is the only person's name on that deed. Betty inherited recently $150,000 from her late mother, and she is nervous about needing long-term care because her mom needed long-term care, so did her father. So she's concerned about long-term care. She's healthy right now, though. So what are we going to do with Betty and Stan? We've got a few issues going on. First of all, since the IRA has declined in value, it might be a good time to consider Roth conversions. And typically you don't do a Roth conversion all in one swoop, but you can consider paying the taxes on the IRA now rather than later, because two things: the account may increase, hopefully it increases in value later, so it's going to be taxed more, and then tax rates could increase in the future. Right now, taxes are historically low. Income taxes are historically low, so you may want to consider paying the IRA taxes earlier. Remember, when you have a traditional IRA, you have to pay the taxes as you pull money out. So a conversion is just paying the taxes a little sooner. With a Roth, you don't have to take distributions during your lifetime. So if this is a legacy element where you don't think you're going to need the IRA money, you may want to convert now. Also, another consideration is that maybe your kids will be in a higher tax bracket because they have great jobs, or you think, again, taxes may just go up, the rates may just go up in the future. So Roths, again, now the account value is lower. So if you convert now, you're going to pay less taxes right now. So again, things like that, situations that arise, it's tough, but there may be hidden benefits to it. Again, when you have a holistic planner, they're going to look at all the stuff with you versus somebody just doing your will, or even worse, you doing your will yourself and not even thinking about this stuff. Remember in the facts, Stan has that IRA, but he only named one of the kids as contingent beneficiary. He cut out the other two because he said the other one will distribute to the others. We know that that's not going to happen, right? So what I told Stan is that let's set up a trust. Let's set up a trust so that the other two will still get their share, but they'll get their share inside of a trust so that they can use it over time. The children don't get along. The dynamics are not good between the family. He was going to name one of them as the backup executor. Not a good idea if they don't get along, because that one's going to have to deal with the others, and that's going to just breed more resentment and potentially cause more problems. So here we are. What do we do in that case where it's natural to use one of our kids as a backup executor after the spouse? Maybe look to nieces, nephews, cousins, friends, coworkers, other people out there that you may trust implicitly. There's also professional options out there as well that aren't used as commonly, but a lot of options out there that may be outside the box. So we want to consider other people that may be a better choice than a child where they're not getting along with the other beneficiaries. And by the way, when you're gone, that relationship may only get worse. And I guarantee it'll get worse if one of them is the executor over the other two. So be careful about that. Florida property, Florida probate is a problem. Probate is the process, by the way, just quickly, of administering an estate. So we hear that word often. It's an evil word in the lexicon of estate planning, and people that come to me and say, I need to avoid probate. Probate's this evil thing. Understood. But probate is actually beneficial because it makes sure under the law that all the beneficiaries are protected, that nobody can just walk off with the inheritance and there's no accountability. So probate has its advantages. When there's a trust and we avoid probate, there's still responsibilities of the trustee because there's whole sets of laws on trust administration. So a trustee can't just walk away with the assets either. But probate has its use. But in the past, and currently with some states, probate is very burdensome because it goes through the courts. It goes through a judge. Every step goes through a judge. Pennsylvania simplified their process so you don't have to go through the courts unless there's a dispute. But Florida is one of these states where it is still burdensome. So we want to avoid probate. So that Florida home, we want to put inside a trust, put the title in the trust while they're still living. That's the living trust. And we want to know why Stan's name is the only one on the deed. Why is Betty's name not on the deed? Was that an oversight? Was that intentional? Did they get the house? Did Stan have the house before they were married? So we'll want to know more about that. I will tell you that a lot of times when I see that, by the way, that's more common than you think. We have real estate spouses. One of the spouses' name is on there. They say to me, both names are on. I look at the deed, there's only one on there. It's more common than we think. We want to correct those things wherever possible. Finally, with Betty and Stan, long-term care. Betty is inheriting $150,000 from her mom, as we said. And she's also concerned about long-term care. So this was money maybe she didn't expect. It might be a good amount of money to use to purchase long-term care insurance. And this isn't your mother's long-term care insurance. This could be long-term care insurance where you pay a single premium. So maybe you put that whole 150 in, maybe you do it over 10 years. But I will tell you the premiums in that type of policy aren't going to go up. And if Betty never uses that policy, her heirs will get at least a return on premium, maybe a little more. So it's not a use it or lose it type of thing. And 150, I don't know what it'll cover. Maybe it's a few $100,000, but it's a pretty good deal if she can get covered. And we said she's pretty healthy. She can also take money in this never money type of bucket, like money that she didn't expect or money she knows she'll never really need. Remember, they have a nice size estate, almost $2 million. Maybe they could put the funds in a Medicaid trust. This is a special type of trust where you do lose control of the assets. So it's a legacy piece, and you're putting it there for your kids maybe. And after 5 years, that's shielded from the cost or from spending it on a nursing home. And so you sort of like shrink your estate a little sooner so that you can go on Medicaid a little sooner. I have a little slide on elder law coming up, but I could spend a whole presentation on that just so you know. There's a couple options when it comes to long-term care. That's Betty and Stan. Let me get us over to Ellen and David. Here we go. Ellen and David are up to bat here. This is also a married couple, but some different facts here. So it's a second marriage for both Ellen and David. They're both also in their mid-60s. Ellen is the only one with kids here. She's got one adult special needs daughter. That daughter lives with them. The daughter's 28 years old. David's got no kids. Ellen inherited a nice chunk of change from her parents, $2 million. They own a house together, Ellen and David. They both have small savings, small IRAs, and that $2 million plus her house is the bulk of their estate. David's going to get a pension of $500 a month, not much, and they're each going to get roughly $2,000 a month from Social Security. They do not have an estate plan right now. They have not done any of the documents that we discussed earlier. Their concerns about their daughter, their concerns about having enough income in retirement. They're both still working right now, by the way, but that's not going to last that much longer. The last point, Ellen wants to make sure that David can benefit from her estate, but not cut her daughter out. Because what we don't want is if Ellen dies first, for David says, yeah, I'm going to take care of your daughter. She's like my daughter. But when Ellen dies, does that change? What if Ellen dies in a year from now versus 20 or 30 years from now? So, and remember, the daughter's young. The daughter's only 28 years old. So we have a lot of interesting issues in this case. Again, with these cases, of course, not all of this will apply to you. Take what you can from your own situation and figure out, hey, is this where I'm at? Is this something that you know, I might have an issue on? Is it something you've thought about before? Hopefully some of this is helpful to you and getting you sort of thinking about how we might design an estate plan. So here are the suggestions for Ellen and David. First, they're going to be put in timeout because they don't have an estate plan. Come on, guys. You got to put this together. You're in your 60s and you haven't done anything and you've got a special needs daughter. Second marriage, like, we're blowing up with issues here. You've got to put this in place yesterday. You don't want to wait, like my clients that came to me, started talking, but then like put it on the back burner again. You don't want to do that. Get it done. I think a lot of times people want to have the perfect plan. The plan's never going to be perfect, okay? And that's why I said earlier in the presentation, you want to go back to it every so often and take a fresh look at it, see what's changed in your life, see what's changed in the laws. See, maybe you want to do something differently. Maybe your priorities have changed. Maybe you become more charitably inclined. So as things change, you've got to update this plan, and don't let the fact that you're not sure about everything hold you back. So by not having any plan, including a special needs trust, we're putting the daughter at a huge risk. There's a couple trusts that we would need here. This is a more complex estate because of the different issues. The second marriage, we want to make sure we provide a trust that, remember, Ellen, I'll go back for a second. Ellen is the one who inherited I'm going to do my laser pointer here. Ellen's the one who inherited $2 million. So that's Ellen's money, okay? So if Ellen dies first, she wants to make sure that she can provide for David, so income in his retirement and beyond, without allowing David to have control over that trust, because he could, if he has control over that money, or let's say there's no trust, he could cut out Ellen's daughter. We don't want to do that, so we need a trust for him. And then we want to put something aside directly, or maybe after David passes, maybe David with that income can still take care of the daughter. We would have to consider how to divide the assets, but we want a special needs trust for the daughter so that she can qualify for public benefits. She's never worked, and the special needs trust is great. You can leave somebody money, but still allow them to qualify for Medicaid and SSI. So it's really important. If you didn't do a special needs trust and you were to leave the daughter money directly, she would not qualify for those benefits. Besides the money and the estate and legal stuff itself, it's important to figure out that living situation and see, right now, the daughter's living with both of them. What happens when they're both gone? Where's the daughter going to live? There's no other kids. So they've really got to put a plan together, a social plan for the daughter, and really think through all of this stuff. The real estate, again, it's both of their homes. They should both be able to benefit from it as long as they live. But again, we don't want David necessarily like cutting out Ellen's daughter if Ellen were to pass sooner. And then there's a lot of retirement planning pieces that come into this. There's going to be a shortfall. Right now, they're earning $150,000 a year together with their Social Security and pension. They're going to have $54,000 a year from that. They're going to have a $96,000 shortfall. When one dies, it's going to be over $100,000 of a shortfall. How do you put that inheritance, that $2 million, to work? That's when we get into the holistic planning, the retirement planning, the investment planning, that really just nestles right in with that estate planning. And that's what we do here at my firm. We don't just do your will. We're going to look at all the stuff for you and with you. So these kind of questions are so common. And I've done so many estate plans over my career, and I can't tell you how many people walk in. I'm surprised. I shouldn't be surprised, but I'm surprised. Like, they have no idea how any of this stuff works. They don't know how their money works. They don't know what they're going to do in retirement. They don't know how much they can take in retirement. We can help you with all of that. So it's time to get it done. But bottom line here is that these guys need a lot of help. They need some trust planning. This is a case where it's not going to cut it just doing a simple will. They're going to put themselves at a huge disadvantage by doing just a simple will. All right, hopefully you're all still with me here. I appreciate your patience, and hopefully, again, if you have questions on any of the stuff, put them in the chat. Just go down to the bottom of your screen. You should be able to click chat and type your question in. We want to hear from you. I'll be done in a few minutes, and we'll take some of those questions. All right, so just a minute or two on elder law. So this is long-term care planning. This is nursing home. This is Medicaid stuff. Again, I could do a whole presentation on this, but I'd be remiss if I didn't hit it at least a little bit. I talked to you with Betty and Stan, the first case, a little bit about her planning with long-term care insurance or a trust. Bottom line is that we're seeing long-term care costs for nursing homes, $175,000 a year and or more in this area. Costs are rising faster than inflation is rising. And you know, inflation, it's not great, right? Maybe it's gotten a little better, but whatever the case may be, throughout my career practice, nursing homes have gone up in price faster than inflation. So keep that in mind. Medicare pays for your healthcare. Medicare pays for like a few days maybe of long-term care, but that's it. It's not going to cover all of your long-term care. Medicaid, I wish they named these programs like with different names that sound more different, but they didn't. But Medicaid is what pays for your long-term care after you so-called run out of funds or you legitimately don't have any money to pay for your care. But you can't do something where you gift everything out the day before you go in the nursing home and then qualify for Medicaid. Okay, that's just not going to fly. You have to do the Medicaid planning in advance. There's a 5-year look-back period right now. Congress, all the time, they're talking about changing Medicaid. Literally, it's been in the news every day that Medicaid rules may change. I don't know if they're talking about the look-back period, but you just don't know what Congress will do. But right now, there's a 5-year look-back period. If you do planning, if you want to do planning in advance, there's a couple of options. There's insurance. So There's traditional long-term care insurance. There's the single premium type insurance with the return on premium that I discussed earlier. There's life insurance, whole life policies with long-term care benefits on them. There's even annuities that have long-term care benefits on them. So there's lots of varieties of products out there. When you sit down with me and you're interested in that, we can run some quotes and look at what products may be best for you. You have to have the right assets, though. In general, that's a point up on the slide here. Though you have to have the right assets to do planning far enough in advance. So, like if your money is tied up in real estate, like your primary residence, and or just all retirement money, like IRAs, it may be hard to do some planning because to pull that retirement money out, it's going to cost you tax dollars. So, you have to be careful and really think through what type of planning you may need. But like somebody like that, if they can get insurance, that may be great. Somebody who inherits assets or has a second home, a trust may make a lot of sense for them, like the Medicaid trust that's irrevocable. If they want to kind of siphon that off, but still have some protection, some ability to use the property without just fully gifting it, that's the next option. There's some retitling, there's other options. These options are highly customized. Again, I could spend a whole hour, a whole month on this stuff, to be honest with you. So I'm not doing it a service justice at all, but I just want to give you a flavor of this. That's pre-planning. If you don't do any planning, that's crisis planning. And that means I'm going to the nursing home. I haven't done any planning. What can I do? Can I preserve any of my assets? Yes, but you must contact an elder law attorney ASAP. If you have anybody in that situation anytime, or you are in that situation and your family needs somebody, they can always contact me. I don't do that type of planning anymore, but I know plenty of people that do. So if you can use me as a resource if you're ever in that situation. But it doesn't help anybody if you wait a year after somebody's in the nursing home and they spent $175,000 of their assets, or they're in 2 years or 3 years and they spent all their money down, and then you go to the attorney. Like, no, we can't claw back the money. There's a lot of myths and urban legends about long-term care out there. I can't get into all of them tonight, but don't buy it. Just, again, do pre-planning where you can, and if there's a crisis, talk to an attorney as soon as possible. All right, so we hit on a lot of things so far. This list just tells you that there's this list could go on and on. There's a number of considerations when we think about our estate plans. So whether it's pets, that's the one on the bottom. Whether it's if you have a small business, succession planning and how that fits into your estate plan. Charitable giving, a big one. We didn't talk about that tonight, but there's lots of different unique and cool things you can do with charitable giving that will benefit you, your family, and the charities. And they're great tax strategies oftentimes. By the way, another tax strategy we didn't hit, life insurance. When it goes to your heirs, it's tax-free, inheritance tax-free. Remember, Pennsylvania has that inheritance tax. There's no assets that are off the table, but life insurance is. Protecting your home, long-term care planning, estate distributions, unique assets, boats, planes, et cetera, intellectual property, royalties, like all kinds of things that may be unique to you that we don't deal with oftentimes. And then family dynamics and conflicts, how to address that and deal with it. These are things that you need to address. And finally, at the bottom, do all of the puzzle pieces in your life fit together? Remember, I showed you the puzzle: investments, healthcare, estate, income, retirement, all that stuff. Does it fit together? Are you working with somebody that can help quarterback all those things for you? So holistic planning, that's what that's called. That's when you're looking at all those different areas, not just one in a vacuum. So again, it includes all those things I just said. At Franklin Retirement Solutions, which is a sister organization of Wechsler Estate Solutions, we do all of that. And we're really good at it, if I may say so myself. And that's all we do. We look at all the stuff together and we help a client holistically to make sure that their plan is in place. You're not going to get that just from an attorney. You're not going to get that just from a stockbroker. You're not going to get that just from an insurance rep. All right. So that's what makes us unique. That's what makes me in particular unique. So I say this stuff, but what is holistic planning? We throw those terms out there, but what does it mean for me? Well, I gave you a few examples. Gifting. If you want to set up a gifting program for children and grandchildren, because you want to make sure that they have money for education or money for other things, but you also want to make sure that it helps with inheritance and estate tax minimization, but you're not sure how much you can afford because you want to make sure you can retire. That goes right into estate and retirement planning perfectly. It's not just one or the other. So you need somebody that's going to help you with looking at it from different lenses. Roth conversions. Okay, it's an estate planning component, but it's also a tax planning component. It's also a retirement planning component, and it could be definitely getting into investment planning. So Roth conversions, a classic one where you need a holistic planner. Life insurance, long-term care insurance, classic one here again, like it goes into tax planning, it goes into healthcare planning, retirement planning, and beyond. You want to set up a trust, but you need assistance retitling assets and setting up proper beneficiary designations to ensure those assets pass into the trust. Again, that gets into your financial advisor. They know of your accounts, but the attorney's doing the trust. Can we meld these two together and marry the two and make it work where it's actually really going to work for you? So those are just some examples of holistic planning and why we do it. All right, so we're getting towards the end and we're going to answer some questions soon. Schedule some time with me. That's the next step. If you'd like, it can be virtual through Zoom or in person. Our office is in Horsham, probably convenient to you. And in that meeting, we're going to review your current estate plan if you have any. We're going to discuss your estate planning goals, and we're going to get you recommendations to turbocharge planning. So you're going to walk out of there with learning something new, whether you work with me or not. And then finally, we're going to determine how that estate plan fits into your bigger picture with all those other puzzle pieces. So the meeting will be complimentary. It's no pressure. I'm not going to try to sell you anything in the first meeting. We're not looking to close a million cases here. We want to make sure that you're comfortable, that we're comfortable, that you're the right fit, that we're the right fit for you. So it's a complimentary, no pressure meeting. You tell us where you want to go after that meeting, and you will learn something new. I guarantee that. So that is the next step. It is really tough to make predictions, especially about the future. All the stuff we talked about tonight, again, if I leave you with anything, you got to go back to it a couple times in your life at least. All right. So I appreciate your patience and your focus during this webinar. We're going to answer some questions if there are any in the chat. And then after that, in the chat, and then in your email as well tomorrow, you'll have a couple links to a couple supplements I have for you, the gifting guide, an estate and inheritance tax and gift tax cheat sheet, and then also a link to my calendar. So you can book right online. You don't have to call or whatever. You can go right on, find a date and time that works for you on my calendar and book it. If you can't find any that works for you, give us a call, talk to Jen, talk to my team here. We'll find a time for you. All right. So with that, I'm going to have Nick shoot me over any questions that we've got here.
I actually was going to read them out game show host style. Does that work?
Go for it.
Okay, so we had a couple come in on chat that were too personal to address. So if you don't hear your question called out, it's too personal of a question. You'll want to have that answered by Jeremy privately. So you'll want to definitely take advantage of that link. But one of the questions that came in was, you touched on deeds with Betty and Stan. Do you have to change your deed because your spouse passes away, or does it transfer automatically if both names were on the deed?
Good question. Typically, you don't have to change it if it's joint because it's called a survivorship deed. So that means that when one person dies, it automatically goes to the other, and you do not have to update your deed, nor really is there anything to update. So you're quite fine leaving it as it is. I always tell folks, and I'm sorry about the loss, just keep a death certificate of your spouse, late spouse, along with your deed. Make sure you have a copy of your deed. If you don't have a copy of your deed, you can go to your county's recorder of deeds office and get a copy probably for a couple bucks. You may be able to get it online as well. That kind of stuff we can help you with if you would like. But again, just make sure one thing we didn't talk about tonight is like organization of all the stuff like your wills, your powers of attorney. That includes deeds. Make sure you have like a place at home. I usually use like a fireproof box to have all these documents in a place that you can find them, and the people that you're putting as executor or power of attorney, et cetera, can find them as well. Good question, though. And I took it a little further.
Okay. So I have another one. It is, do beneficiary forms expire? If you are the beneficiary for an account, how long do you have to return the transfer paperwork?
I truly don't know that they expire. I mean, somebody's a beneficiary, then as long as they're alive, they probably should claim it sooner than later. After a while, it depends on the individual company's policies. So we'd have to look at the policy, like a Prudential versus Vanguard or versus Schwab versus New York Life. They may have different policies on that. Sometimes when after a few years go by and somebody still hasn't claimed something, it could go into unclaimed property. Pennsylvania and a lot of other states have an unclaimed property website where you can search for unclaimed property. You may want to do that tonight, by the way. See if you have anything that is yours that you didn't claim and make a claim on it. But if you're aware that you're going to inherit something and you have indeed inherited something, you want to claim it sooner than later.
Okay, and then on to probate. We talked about it. We didn't really go in depth. Where is the best place to find out what asset types pass through probate?
You'll know that an asset is going to be part of your probate estate or will go through probate if it's just in your name only and you don't have a beneficiary on that account. So I have a bank account. My checking account is a Citizens Bank. That only has my name on it. I have not named a beneficiary. So when I die, that will go through my estate. Conversely, if my Citizens Bank account had myself and another person as joint owners, it will go to that joint owner upon my death. If the bank account says that it's in Jeremy's trust, that's the title of the account, it will avoid probate and go into my trust at my death, or it's already part of my trust, actually. If I have a beneficiary designation, I've named you, Nick, as the beneficiary. Lucky you.
I feel honored.
Get that free of probate. Yeah, I don't know how much is in there, though. But that's how you know. You know by the titling. If it's, again, the key with probate, if it's just in your name and there's no beneficiaries, it's going through probate. That's how you always know.
Okay, and two more. So if you have a document that names an executor, or if you're going to have a power of attorney, do you just have to name one person? Can you name two?
So you always want to have a primary and at least a couple backups, but you don't want to name two people together. Like you don't want to name me and you as the primary executors, as co-executors, at least in my strong opinion and a lot of other attorneys' opinions, because it causes potentially a lot more problems. Just imagine if you and me, we have a dispute. Like let's say we have a house that we've got to sell and you think we should fix it up and spend $100K on it. I think we should sell it as is, and we can't. How do we resolve that dispute? And it may spin out of control and into other things as well and other issues. And lo and behold, we're both getting attorneys and the estate's paying the bill. It's not good. Have one person do it. It's like a CEO. You want to have one person in that power to do it, and then a couple of backups. Don't make it harder on your family and more complex.
All right, and this one came in via email. This is the last one I've got to answer. If I'm not fully convinced about a living will or an advance directives, can I sign it and then change my mind later? Once a living will is in place, can you change it?
Yeah, so this is our healthcare piece. Because that's a good question, because a lot of clients are uncomfortable sometimes with their living will. Like, I'm going to make decisions about my end of life right now. Like, what if something changes? I get that. So bottom line, with that document, with a financial power of attorney, with a will, with a revocable trust, those are all revocable documents. As long as you're living and as long as you're competent, you can change those anytime. How do you change it? Just by doing a new one and ripping up the old one. So you can change it. Don't, as I said earlier, don't let don't wait for the perfect plan, because you'll never have that perfect plan. Do the best you can, and then go back and update it over the years. That's definitely possible, doable, and normal.
Okay, that is it for the questions. If you guys want to check the chat window here in just a moment, after I kick my printer, I will have the link for tonight's deliverables and documents that you were promised. And again, that email will go out tomorrow. Jeremy, parting words. I'm going to mute my microphone again.
Now's the time to do your planning. Strike while the iron's hot. While you're thinking about the stuff, you've taken a good first step just by joining tonight. Now's the time to take some action. It doesn't have to be with me. I'd love it if it was with me, but if it's with somebody else, I'm just glad you're doing it. Just get it done and then go back to it every few years, and don't do it yourself. All right. Thank you guys so much for signing up, for joining us tonight for the questions. Nick just sent you the link in the chat. So click that link so you have it. If you don't get it for some reason, or it doesn't, you log, whatever the case may be, if you can't get it right now, we will send you an email if you've registered for the event. If you haven't registered for the event and you want that in email, you've got to email us. We have the email right on the screen, team@wechslerestatesolutions.com. So again, if you're on tonight, but you didn't register to come on, which is totally fine, but you want that email, make sure you email us, team@wechslerestatesolutions.com. I know it's a mouthful, but there it is right there, okay? Thank you guys so much, guys and gals, so much. Hopefully I'll be seeing you around. Have a great night.